Hello, I'm Paola Sproul. I'm here today to talk to you about the case of Hastings. Hastings was the lead case on a medical implant. The seminar will cover that case, product liability and the legal landscape at the time, as well as the lessons learned in running a product liability case. Hastings was the first product liability proof involving a medical implant to be heard in Scotland. The medical implant was a hip replacement made of metal components, commonly termed a metal-metal hip, or MOM. The case dealt with the safety of that particular hip implant. We will look at the case, its significance for product liability in terms of how the court interpreted the relevant section on safety, being Section 3 of the Consumer Protection Act 1987. Finally, I will reflect on the lessons learned in running a product liability case. Let me start by presenting the pursuer, Mr. Hastings. Mr. Hastings was a former forestry worker. He underwent a total hip replacement to his left hip due to arthritis in March 2009 when aged 54. The hip implant he received was a ball and socket joint made of cobalt chromium alloy. This implant was manufactured by the defenders. After a few years of the hip replacement, he started to suffer pain in his left hip. When he was reviewed at the Orthopaedic department, he was found to have raised metal ion levels in his blood. He developed pseudotumours, that is, fluid collections causing inflammation and pain. These symptoms were considered to be due to the metal hip implant. I will explain more about this later. He was recommended revision surgery, that is, to have the hip implant removed and replaced with a non-metal hip implant. He underwent revision surgery in October 2018. In 2015, we raised a personal injury action against the manufacturers for the injury caused by the implant and the need for the premature revision of the left hip. The action was based on product liability. It was claimed the implant was defective under Section 3 of the Consumer Protection Act 1987 because the implant was not as safe as persons generally were entitled to expect. That is the definition in terms of the Act. So, what is the problem with metal hips, I hear you say? Metal hip components are made of the metals cobalt chromium. These metals are well known for their cytotoxic effects. The articulating parts of the components release metal ions into the bloodstream as they slide against each other. Friction causes tiny particles of metal debris to break off and enter the space around the implant. This triggers inflammation, discomfort and damage to tissue and bone surrounding the implant and the joint. The implant may become loose and require revision surgery. Symptoms reported include high metal ion levels, that is cobalt chromium in the blood, muscle damage, bone damage, fluid collections or pseudotumours, soft tissue damage, medically known as ALVAL, metallosis or ARMD. ARMD being the acronym for adverse reaction to metal debris. Other symptoms include pain in the hip, groin or leg, limping, swelling of the hip joint. If we look at the diagram of the total hip replacement, you'll note it has three components. A cup or socket, known as the acetabular component, which replaces the worn-out hip socket. There is the ball or head, which replaces the head of the femur. That is the thigh bone. This is usually made from cobalt chromium alloy, stainless steel or ceramic. The stem, known as the femoral component, fits into the femur. The stem is usually made from stainless steel, cobalt chrome alloy or titanium alloy. In Mr. Hastings' case, the head and socket were made of cobalt and chromium and the stem was made of titanium. The release of metal ions was claimed to be at two junctions, the ball and socket joint and also the junction of the stem and the head, known as the trunnion. It was claimed that there was additional wear at the trunnion due to the titanium stem being of a softer metal than the cobalt chromium head. Furthermore, As the implant Mr. Hastings received was a large head metal hip implant, that is, with a width over 36mm, it was shown that these had a tendency to wear down faster. Multiple studies and research organisations had warned about cytotoxic potential of metal hips. Cobalt and chromium lead to genotoxic changes in both laboratory settings and animals, as was described in scientific journals 40 years ago. On the other hand, a total hip replacement is the most common orthopaedic procedure, restoring mobility to many. So how did Mr. Hastings come to be implanted with a metal hip? Conventional total hip replacements consisted of a metal head and polyethylene cup and required revised in younger, more active people as the joint wore out. In the 1960s and 70s, surgeons were looking at ways to preserve more bone. Metal, that is the combination of cobalt and chromium, was considered to be more durable. From 2006 onwards, metal hip replacements became increasingly popular. Metal hips were aggressively marketed by orthopaedic companies and became increasingly popular in the West of Scotland hospitals. Contrast the position in the East of Scotland, where the surgeons were much more guarded and wary of offering a product which had not undergone any long-term testing or studies, so much so that the orthopaedic companies called the surgeons dinosaurs. When Mr. Hastings was offered a metal hip, it was claimed it would last a lifetime. Sadly, this did not turn out to be the case. In 2007, the MHRA Committee on Safety of Devices recommended all patients sign consent forms setting out the risks associated with metal wear debris. In 2008-2009, there were reports of increased complications and failure rates associated with MOMs. The average failure rates at 7 years were 13.6% for metal total hip replacements, although failure rates varied with brand. This compared with rates of only 3 to 4% for hip implants made of other materials. MHRA device alerts in relation to metal hips were issued in 2010, 2012, 2013 and 2017. These recommended increased monitoring of patients with metal hips, including yearly blood tests to check metal ion levels. Okay, so having set out the factual background to this case, we will now look at the legal framework. As I said, Hastings proceeded to a 3-week Court of Session proof in May 2019. The proof was on liability only, namely the issue of whether the product was defective in terms of Section 3 of the Consumer Protection Act 1987. Section 3.1 provides that, subject to the following provisions of this section, there is a defect in a product if the safety of the product is not such as persons generally are entitled to expect. In determining for the purpose of subsection 1 what persons generally are entitled to expect in relation to a product, all the circumstances shall be taken into account, including the manner in which and the purposes for which the product has been marketed, its get-up, the use of any mark in relation to the product and any instructions for or warnings with respect to doing or refraining from doing anything in relation to the product, what might reasonably be expected to be done with or in relation to the product, and the time when the product was supplied by its producer to another. And nothing in this section shall require a defect to be inferred from the fact alone that the safety of a product which is supplied after that time is greater than the safety of the product in question. Based on this statutory definition and the particular implant being looked at, the parties agreed the following question before the court. Does the inherent propensity of a metal hip prosthesis to shed metal debris through wear, in use, including trunnion wear, and the admitted risk that some patients may suffer an adverse reaction to such metal debris that may necessitate early revision, render the product less safe than persons generally were entitled to expect, and thus defective within the meaning of the 1987 Act, taking into account all the circumstances including the following particular circumstances relied on by the pursuer. Firstly, the knowledge reasonably to be expected of the body of orthopaedic surgeons responsible for advising patients as to the choice of prosthesis, pre- and post-supply, the sufficiency of the disclosure of the likelihood and severity of such risks of the product within the literature supplied in relation to the product, including the instructions for use, in particular having regard to point 1, advice and warnings issued by the relevant regulatory authorities post-supply, advice and warnings issued by the manufacturers and suppliers post-supply, the combination of titanium alloy stem and cobalt chromium head, the date of supply of the product, the fact that the product is no longer supplied. The product was identified as the combination of the Mitch acetabular cup and femoral head and accolade stem. As can be seen from the earlier slides, there are many facts and circumstances that require to be taken into account in determining whether a product is as safe as persons generally are entitled to expect. If this could be distilled into one short question, it would be, what is the entitled expectation in relation to that product? In Hastings, we argued that the pursuer, in common with persons attending for a hip replacement, was entitled to expect the following minimum requirements from the implant used in his operation. Firstly, that the implant would remain on the market, that the product had and continued to have regulatory approval, that the orthopaedic community would continue to sanction its use, that the manufacturer would not warn against its continuing use, that the instructions for use, IFUs, should be legible and adequately warn of risks. The defenders argued that there was no evidence to support the conclusion that the outcome of the hip revisions generally and the product itself was abnormal to give rise to a defect. They argued that other non-metal-metal hip implants released debris, and the pursuer had failed to prove that the metal-metal hip was significantly worse than non-metal-metal hip implants. The defenders explained away the withdrawal from the market as a commercial decision and claimed the statistical data on which the withdrawal notices were based was unreliable. In his judgment, Lord Tyre analysed several cases on the safety of medical products and medical implants. These were the following cases: the Boston Scientific case, A versus the National Blood Authority, Wilkes versus Dupuy International Limited, and G versus Dupuy International Limited. As I said, I will only go into detail in relation to the cases of Wilkes and G, as they both relate to hip implants and are more of relevance in demonstrating the legal landscape at the time Hastings went to proof. They were also both referred to in Lord Tyre's opinion. In Wilkes versus Dupuy International Limited, the claimant had undergone a metal-metal total hip replacement using components manufactured by the defendants, which included a steel femoral shaft called a C-stem. The stem fractured, and in the course of revision surgery, there was evidence of metallosis around the joint. There was a trial on the preliminary issue of whether the stem was defective under Section 3 of the Act. Justice Hickinbottom considered it was not. He stated a number of propositions regarded as uncontroversial. Once again, these propositions were relied upon by Lord Tyre in his opinion. Firstly, the Directive and Act focused not on the acts and omissions of those involved in production, but rather upon the condition or state of the product itself. The condition of the product required by the Directive and the Act is not put in terms of fitness of purpose or efficacy, but rather in terms of safety, and only in terms of safety, the hallmark of defect being the lack of safety. Safety is inherently and necessarily a relative concept. In the case of a medical product, there cannot be a sensible explanation that is entirely risk-free. Potential benefits have to be balanced against risks. The test for safety requires an objective approach. The level of safety is not assessed by reference to actual expectations of an actual or notional group of individuals. It is concerned with a reference to an entitlement as a matter of law. It follows that in considering whether a product suffers from a defect, the court must assess the appropriate level of safety, exercising its judgment and taking into account the information and the circumstances before it, whether or not actual or notional patient or patients, or indeed other members of the public would in fact have considered each of those factors. Although a claimant must prove causation in the sense of showing a causal link between the defect and damage, he is not required to prove the case of that lack of safety or why the product failed. In considering avoidability of the risk, he commented, "There is a danger in focusing upon the acts and omissions of the designer or producer of the product rather than the product itself. However, I consider that whether and the ease with which and extent to which a risk might be avoided may, in appropriate cases, be a circumstance that is relevant to the question of safety and therefore defect under the Act. Although, in respect of a medicinal product such as prosthesis, I consider a detailed consideration of the discrete question of whether a particular risk is or is not avoidable is unlikely to be fruitful." Timing is everything. In May 2018, exactly a year before the proof in Hastings, the English High Court issued the decision in the case of G versus Dupuy International Limited. This related to 6 lead cases heard in the English Litigation Order, GLO, dealing with 312 individual claimants who had been implanted with one or more Pinnacle MOM implants manufactured by the defendants. The English court ruled against the claimants. In short, the court considered that the Pinnacle prosthesis was not defective in terms of the Consumer Protection Act 1987, and that the claimants had failed to prove that it did not meet the level of safety that the public generally were entitled to expect at the time that prosthesis entered the market in 2002. In finding that the prosthesis was not defective, the court held the inherent propensity of an MOM hip to shed metal debris through normal use, to which some patients may suffer an adverse immunological reaction, is not a defect in the product within the meaning of the Act. It did not become a defect by reason of the recorded incidence of such adverse reactions or the calculated risk of the probability of the revision of the prosthesis on account of them. The claimant failed to prove that the Pinnacle prosthesis had a greater risk of failing within the first 10 years after implant than a comparator prosthesis, and thus that the product carried with it an abnormal risk of damage. Whilst we did not accept the manner in which cases were dealt with in the English GLO and were not bound by the decision, it was a significant decision for all metal hip cases in Scotland, and a useful test case for our own test or lead case in Hastings. So it was against this backdrop of a couple of English decisions that were found against the claimants that the case of Hastings came to proof in May 2019. What had become clear from these earlier decisions was that in addressing the question of what persons generally well entitled to expect in relation to the safety of a product, the issue of safety was in this context a legal concept. It was for the court to decide the question of what was entitled to expectation in relation to the metal hip implant, as it was a proof on liability only, and this one question to be determined by the court. Only expert evidence was laid by the parties. The pursuer did not require to give evidence. The court timetable fixed in the 6-month period prior to the proof had been structured to allow for the leading of concurrent evidence, or hot tubbing as it is more colloquially called. The 3-week hearing was taken up with the expert evidence of a total of 10 experts for both parties, from a wide range of medical and scientific backgrounds such as orthopaedic surgeons, biomechanical engineers, histopathologists, toxicologists, immunologists, and an epidemiologist. The evidence led by the pursuer's experts focused on demonstrating the following: that metal debris had caused greater problems than expected at the time of supply of the product. The regulatory authorities had issued warnings about it post-supply. The orthopaedic community had stopped using the product. The defenders had stopped selling the product. The defenders had themselves issued safety notices in the UK and Australia warning against its use. The defenders' instructions for use were illegible and inadequate. There was misleading promotional material that was provided with the product. The defenders' experts sought to demonstrate the following. There was no reliable evidence to support a conclusion that the outcome of metal-metal hip implants was abnormal so as to give rise to a defect. Non-metal-metal hip implants can shed debris, which is potentially harmful and require early revision. The data on which the warnings were issued was unreliable. The product was withdrawn from the market for commercial reasons. Turning now to Lord Tyre's opinion in the case of Hastings. Lord Tyre issued an 84-page opinion. In his opinion, he decided that despite the expressions of serious professional concerns, followed by the issuing of official alerts and the withdrawal from the market of the entire range of products, all of which constituted a prima facie powerful evidence the product was defective, the pursuer had failed to prove that it had not performed in accordance with the entitled expectation based on the statistical evidence led by the defenders. The decision has now been appealed, primarily on the grounds that there was such powerful scientific and medical evidence produced by the pursuer that the product was defective, whereas the statistical evidence produced by the defenders was unreliable. We will also argue that there was too high an evidential standard imposed on the pursuer as the consumer making the claim. The appeal hearing will be heard before the Inner House on the 2nd and 3rd of December 2020. We'll now look at some of the lessons to be learned in running a product liability proof, such as Hastings. Firstly, expert evidence. This is key in establishing what is the entitled expectation in relation to the product. Bear in mind that safety is a legal concept. The burden remains on the pursuer to lead the necessary relevant expert evidence to inform the court on how the expectation was not met in the particular case. As with any proof, it is important to identify a relevant and recognised expert at an early stage and to consider the defender's likely propositions to bridge any gaps in evidence. This may require a myriad of experts and consideration of the prominence to be allocated to their evidence. For example, in the Hastings case, it was evidence of orthopaedic surgeons that we argued was the starting point in determining the entitled expectation. After all, when seeking the advice on the safety of a proposed hip implant, would you rely on the advice of an orthopaedic surgeon or a biostatistician? Strategy is also important. Where a lead or test case is being selected out of a group, then get ahead of the game as the pursuer. This is particularly important if a selection process with the defenders is to be avoided. Hastings was one of 80 metal-metal hip cases selected for its stronger features. Court timetables had been fixed in a number of other cases, but we ensured it was ahead of the others and a proof was fixed before the defenders realised they had no choice in selection. Prepare an analysis of selection criteria to select a case with strongest features. In a lead or test case, you're looking for a case with the most supportive evidence on liability and causation. You're also looking for a pursuer who's reliable and a good historian. That goes without saying for any proof and not just a product liability case. Finally, keep pushing the boundaries. The product liability decisions issued by the courts so far have not been decided adopting a consumer-friendly approach. The driving force behind the directive was the thalidomide scandal and the need to increase consumer protection by introducing a strict liability regime rather than relying on common law negligence. One of the reasons for imposing the strict liability was in recognition that the manufacturer has a knowledge and understanding of the product that no consumer can hope to have. This is not a fair apportionment of risk. If the courts then impose a too high evidential burden on the pursuer, this makes it even more difficult to establish product liability. In the Hastings case, the pursuers pulled the product from the market, making it difficult for the pursuer to produce any statistical evidence. It is this imposition of too high an evidential standard, the inconsistency with the objectives of the directive and the principles of fairness, that is the basis of one of the grounds of appeal. It is hoped that the appeal will enable a more balanced and consumer-friendly approach to be taken by the courts in future when looking at the safety of a product. To conclude, the defenders may have won another battle in Hastings, but they have not won the war. Thank you for listening to this presentation. I hope you found it useful. Should you have any comments or feedback, then please email these to me. Thank you for listening.